Hello, my name is Vedant. I am a legal intern with LEXIS and Company. In this video, we will understand and we will learn whether the sentences or different sentences awarded by the trial court would run concurrently or consecutively. In the recently decided case of Sunil Kumar and another versus State of Uttar Pradesh, Division Bench of Justice Dinesh Maheshwari and Justice Aniruddha Bose at the Supreme Court has made it abundantly clear once again that it is legally obligatory for the court of the first instance, that is the trial court, while awarding multiple punishment of imprisonment, to specify in clear terms as to whether the sentences would run concurrently or consecutively. The omission of the state whether the sentences awarded to the appellant would run concurrently or would run consecutively essentially operates against the accused, because unless stated by the court, multiple sentences will run consecutively as per the plain language of Section 31 Clause 1 CRPC, read with exposition in the decided cases of Muthuramalingam versus State. The other omission to state the order of consecutive running cannot ipso facto lead to the concurrent running of sentences. Faced with the position that the stated omission will not by themselves provide room for concurrent running of sentences, the appellant's counsel has endeavored to invoke the single transaction principle. In the Supreme Court's view, the said principle is essentially referable to Section 220 CRPC, which provides that if more offences than one are committed in a series of acts so connected together as to form the same transaction, then the accused may be charged with and tried at one trial for every such offence. In the given case, after such trial for multiple offences, if the accused is convicted and awarded different punishment, concurring running thereof may be provided depending on the facts and the relevant surrounding factors. This principle related to single transaction cannot be imported for dealing with the question at hand. In its decision of the case Mohan Bhatia versus and others versus State of Bihar, the Supreme Court observed that the expression same transaction from its very nature is incapable of an exact definition, and it is not possible to enunciate any comprehensive formula of universal application for the purpose of determining whether two or more acts constitute the same transaction. The question involved in that case did not relate to sentencing but to the inquiry and trial of different offences pertaining to Section 304B, 498A, 120B and 406 of the Indian Penal Code and the territorial jurisdiction of the magistrate in Bihar, when the alleged incident constituting one of the offences under Section 104B IPC had taken place in the state of Uttar Pradesh. Of course, in the decision of the case is the case Mohammad Akhtar Hussain versus Assistant Collector of Customs Ahmedabad and another. The SC indicated that if a transaction constitute two offences under two enactment, generally it is wrong to have consecutive sentences, but such a rule shall have to apply if the transactions relating to the offences is not the same or the facts concerning the two offences are quite different. Significantly, in that case, consecutive running of sentences awarded to accused appellant in two different cases pertaining to the Gold Control Act 1968 and the Customs Act 1962 was held by the Supreme Court with the finding that the two offences for which the appellant was prosecuted were quite distinct and different. The only modification ordered by the SC was concerning the term of imprisonment for the latter conviction, while disapproving its enhancement from 4 years to 7 years by the High Court after noticing that he was already sentenced to imprisonment for a term of 7 years in the first offence. However, the other part of his submissions that running the appellant to serve a total term of 22 in prison would be highly disproportionate to the actual punishment they need to suffer in this case cannot be brushed aside altogether unworthy of consideration. After anxious consideration of all the relevant factors, the court has been of the view that the requirement of complete justice to the cause before the court could adequately be met by providing that the maximum period of imprisonment to be served by the appellant shall be 14 years and not beyond. This order was passed only in the peculiar facts and circumstances of this case. However, SC's High Court's order regarding payment of fine and default stipulation have been kept intact in terms of the order passed by the Allahabad High Court on 21st January 2018. While closing the case in result, the Supreme Court partly allowed the appeal, reminding all the concerned of its observation in the decision of the case Nagarjara versus Central Bureau of Investigation that it needs hardly an emphasis that any omission to carry out its obligation by a trial court to specify as to whether the sentence of imprisonment awarded by it would run concurrently or consecutively causes unnecessary and avoidable prejudice to the parties, both the accused and the prosecution. Thank you.